So dear students, today we are going to learn the concept of writ of habeas corpus. Habeas corpus is a Latin word which literally means to produce the body, and it is a writ guaranteed under Article 32 of Constitution of India. Supreme Court can issue habeas corpus writ under Article 32. Likewise, the various high courts of our country are also authorized to issue writ of habeas corpus under Article 226 of Constitution of India. If, if police has arrested me illegally, they have detained me illegally, they are not producing me before the magistrate as required by law within 24 hours, I can file a writ of habeas corpus either in the High Court or in the Supreme Court. Why it is so, dear students? Because Article 21 of our Constitution grants us and protects the life and liberty of individual. And this life and liberty cannot be taken away except according to procedure established by law. And this Article 21 is the fount of the protections guaranteed under habeas corpus. Similarly, Article 22 of Indian Constitution safeguards the interest of those persons who are detained under preventive detention laws. And this article, that is 21, 22, also protects the body of a person from illegal detention. If I am detained by the police illegally, habeas corpus will lie. If I am being detained under preventive detention laws, but not in accordance with law, then definitely a writ of habeas corpus will lie. In other words, dear students, habeas corpus means you may have the body. Why police has arrested me? And they are not releasing me. Neither they are informing my family members. They are hiding my body in illegal confinement. So I have a fundamental right of filing a writ of habeas corpus, which means you have the body. And it is a process by which a person who is confined in jail without legal jurisdiction may secure a release from his confinement. And this writ can be made by any person on behalf of prisoner as well as the prisoner himself. Because if I am detained by the police, I am in jail. How I will file a writ? Either in the High Court or in the Supreme Court. Although I have a right to file my writ through jailer also, but that takes a long time. So writ can be filed by any person on my behalf because I am confined in jail. Any of my family member, my advocate, any NGO, any public spirited person can file writ of habeas corpus on my behalf. And dear students, this habeas corpus does not merely mean that my body should be released from confinement. If I am being confined in inhuman and degrading conditions, still it affects my right of life and liberty. And habeas corpus writ will lie if ladies are kept in inhuman conditions and degrading conditions in Agra home. In every district there is a home meant for ladies. But the conditions inside those homes are very bad. So our Professor Upendra Bakshi and Lotika Sarkar Madam, they are the professors of Delhi University. They taught me during LLM also. They filed a PIL, habeas corpus, on behalf of inmates of Agra home, and the directions were issued by the Supreme Court. This writ of habeas corpus is an effective means of immediate release from unlawful detention, whether in jail or in private custody. The right to life and liberty of inmates under Article 21 is violated if inmates are living in inhuman conditions and degrading conditions in Agra home. So it is not only the release of the body, but the conditions inside the jail, conditions inside the home meant for ladies should be human and not degrading. So dear students, this habeas corpus is an ancient common law writ issued by court or a judge directing one who holds another in custody to produce the person before the court for some specified purpose. When a person is kept in illegal confinement, you make a prayer under habeas corpus that detainee may kindly be produced before the court so that he may be released. Although there have been and there are many varieties of writs, the most important is that used to correct the violation of personal liberty by directing judicial inquiry into the legality of detention. And this writ is known as a writ of habeas corpus. If you take simple dictionary meaning of the writ of habeas corpus, a writ requiring a person under arrest or illegal detention to be brought before a judge or into a court, especially to secure the person's release unless lawful grounds are shown for their detention. If no grounds are shown for detention, then the result of habeas corpus is that if police has detained me illegally, I will be released by the High Court order immediately. An order will be issued when I file writ of habeas corpus. This great writ of habeas corpus, dear students, is a fundamental right in our constitution. Because Article 32 gives you right to file this writ straightway in the Supreme Court. And it protects me against unlawful and indefinite imprisonment. If you see the translated version of habeas corpus, it means show me the body. Produce my body before the court. Why you have illegally detained me? So dear students, this habeas corpus has historically been an important instrument to safeguard the individual freedom against arbitrary executive power. The simple meaning of writ of habeas corpus is the writ of habeas corpus is the requirement that an arrested person be brought before a judge or brought before a court before he is detained or imprisoned. But even if he is not produced before the court or the judge and is straightway sent to the jail, or police has confined me at an unknown place, still later on I have a right to file writ of habeas corpus before the Supreme Court or before the High Court. So dear students, this writ of habeas corpus gives the jailed suspect the right to ask a judge to set them free or order an end to improper jail conditions. If my confinement is without authority of law, then I can make a prayer before the High Court judge or Supreme Court judge to release me immediately. Or at least I can pray to end the improper jail conditions. If conditions in the jail are not good, the food provided to the inmates is very bad. Sleeping conditions, living conditions are bad. So those conditions can be ordered to be improved under writ of habeas corpus. It is not only the question of your body which has to be released, but it is a question that your body must be confined according to law and in proper jail conditions. Proper hygienic jail conditions, hygienic police custody if allowed by law. Then if you compare the law with American position, dear students, habeas corpus started in American law in the first article of USA Constitution. See the importance of habeas corpus. That the first article of USA Constitution speaks about habeas corpus. And it says that this writ protects any person who gets arrested from staying in custody for no good reason. It forces law enforcement or government bodies to show good cause for keeping a person in custody. Police has to show cause. The state has to show cause as to why I was being detained, under what law I was being detained. And if there is no explanation, the result of habeas corpus will be that I will be released from jail immediately. I will be released from police custody immediately if the custody is not in accordance with it. Now, dear students, whether this fundamental right of habeas corpus can be suspended in India? No. Answer is big no. The Constitution was amended by 44th Constitutional Amendment Act 1978, and this amendment has provided that Article 21 relating to personal liberty cannot be suspended even during emergency. If emergency is proclaimed under Article 352 by President of India, still Article 20 and 21 cannot be suspended. In this way, personal liberty has been strengthened and writ of habeas corpus retains its potency even during emergency. You cannot detain me without authority of law, even if emergency is proclaimed by the President of India. Now the question is, next related question, whether habeas corpus writ can be filed against a private individual. So the position of law, dear students, is that a writ of habeas corpus is issued for release of a person who has been detained unlawfully by the state or even by private individual. Even by private individual. So a habeas corpus writ is to be issued only when the person concerning whose liberty the petition has been filed is illegally detained by a respondent in the petition. The opposite party, police. Opposite party, CBI. Opposite party, state government. They have illegally detained me. I am the petitioner and my liberty has been violated. Okay. Moving further to the illustrations through case law, we have a very old and very important leading case, A.K. Gopalan versus State of Madras, decided by the Supreme Court way back in 1950. Mr. A.K. Gopalan was a communist leader. He was detained in Madras jail under Preventive Detention Act 1950. His detention was preventive detention, not punitive. He had committed no offense, but punitive, preventive detention. Under Preventive Detention Act 1950, he challenged his detention on the ground of his fundamental rights and questioned this legislation, questioned this law, that is Preventive Detention Act 1950. The Supreme Court held that the preventive detention does not abridge the detainee's right to freedom under Article 19. Even if I am under preventive detention, my freedoms under Article 19 are not taken away. The procedure established by law in Article 21 are unique in relation to due process law as referenced in US Constitution. And Article 22 empowers the Parliament to legislate on the subjects of preventive detention. Yes, Parliament can make laws, but that law should be fair and reasonable to the arrested person. A law that affected the life and personal liberty could not be declared unconstitutional only on account that it did not follow the due process of natural justice. This means that Article 21 provides no protection against such legislative actions, and this was a narrow interpretation of Article 21 given by the Supreme Court. And till date, this judgment is being criticized in the legal circles. And Supreme Court said that Preventive Detention Act of 1950 itself provides a procedure established by law. So a narrow interpretation of personal liberty under Article 21 was taken by the Supreme Court because they did not allow the writ of habeas corpus, saying that your detention is okay under Preventive Detention Act 1950. Supreme Court refused to go into the details of this act, which was harsh and unreasonable, and Mr. A.K. Gopalan was detained under this act. Then we have a famous habeas corpus case, ADM Jabalpur versus Shivkant Shukla. In this case, Shivkant Shukla was detained under MISA 1971, Maintenance of Internal Security Act 1971. He challenged his detention in a habeas corpus petition. Supreme Court held that since by presidential order dated 27 June 1975, no person has any locus standi to move any writ under Article 226 before the High Court for habeas corpus. You cannot move a writ of habeas corpus because emergency is in operation under presidential order. You cannot move any High Court for habeas corpus or any other writ or order or direction to challenge the legality of an order of detention on the ground that the order is not under or in compliance with the act, or order is illegal, or is vitiated by malafide, actual or legal, or is based on extraneous considerations. Court also upheld the constitutional validity of section 16 capital A clause 9 of MISA, and they said that MISA 1971 is the procedure established by law under which they have been detained. So the plea of petitioner Shivkant Shukla was not heard and their detention was held as constitutional. Again, this judgment is being criticized in the legal circles till date. And this is, my dear students, the most infamous judgment of the Supreme Court, in as much as a very narrow meaning was given to the concept of personal liberty. When you are not ready to see the reasonability of the provisions of MISA, and you are saying that MISA itself is a procedure established by law and the detention is constitutional, that means you are taking away my personal liberty. You are not permitting me, you are not allowing me my habeas corpus petition. Conversely, you are giving very narrow meaning to my personal liberty. Had this petition of habeas corpus been allowed, and section 16 of MISA would have been declared unconstitutional, then I was entitled to my full personal liberty. Then there was a meaning of habeas corpus. But unfortunately, in this infamous judgment, Supreme Court interpreted the concept of personal liberty in a very narrow manner. But don't worry, dear students, now the ratio decidendi of this ADM Jabalpur case has been overruled. And the overruling judgment is Justice K.S. Puttaswamy versus Union of India relating to right to privacy. This judgment was delivered by the Supreme Court in 2017. So dear students, so far as habeas corpus is concerned, I told you in the beginning also that the general rule is that this writ can be filed by the person who is illegally detained. If I am confined in jail, I have a right to file this writ. But in certain cases, this writ can be filed by any person on behalf of prisoner also. It can be filed by my friend or my family member or my relative or my advocate or any other person. NGO can file a writ of habeas corpus on my behalf. See, we have a very good illustration of relaxation of rule of locus standi, that is filing of writ petition by another person on behalf of somebody else. And the illustration is Sunil Batra versus Delhi administration. In this case, a letter was written by Sunil Batra to the Supreme Court alleging that the jail warden had caused a brutal bleeding injury to another convict, Premchand, and thus torture was practiced upon him. This letter was treated as a habeas corpus petition, and it was held that writ of habeas corpus can not only be used for releasing a person illegally detained, but it will also be used for protecting him from ill treatment inside the jail. See, if a convicted person was being beaten brutally by the warden, it affects his life and liberty. So habeas corpus is not only meant for release of the person, but habeas corpus can be used for protecting the convicted person from ill treatment inside the jail. Jailer has no right to give ill treatment. If he is doing so, he can be directed not to do so in a habeas corpus petition also, because ill treatment affects the life and liberty of the convicted person. Now see another dimension of habeas corpus. Habeas corpus can be issued for custody of children between husband and wife also. You see, after the divorce, generally there is a contest between husband and wife as to who will keep the young children. And father as well as mother both have equal affection. They want that kids should be given to their custody. So whether habeas corpus will lie? Yes. Sarita Sharma versus Sushil Sharma is the answer, is the case law. That in this case, after divorce, husband filed a habeas corpus petition for custody of children under Article 226. And petition was allowed by Delhi High Court. The wife was directed to hand over the children to the husband. Matter reached the Supreme Court. Supreme Court reversed the order of the High Court of Delhi, looking into the welfare and interest of the children and their wishes also. Why? The husband here was in habit of taking excessive alcohol. Husband was staying with his mother who was 80 years old. There was no one in the family to take care of the children. Hence, custody of child was restored to their mother of the kids. And it was held that habeas corpus writ is maintainable for custody of kids also. So, kids were in private custody and habeas corpus was held to be maintainable for proper custody of the children. Then, dear students, we have a very big illustration of habeas corpus, Rudul Shah versus State of Bihar. I like this case very much. Rudul Shah was detained in jail for an offense. He was duly acquitted by the competent court. After acquittal, you know, the release order is sent to the jail so that jailer may release you. So the release order was also sent to the jail. But see the luck of Rudul Shah. He was detained for long 14 years, even after his acquittal, and his personal liberty was violated for 14 years. He filed a writ of habeas corpus in the Supreme Court. Supreme Court awarded a compensation of 30,000 rupees to Rudul Shah for illegal detention. See the beauty of writ of habeas corpus. A person who was acquitted by the court, he was being not released from jail for long 14 years. And I think this is possible only in state of Bihar, not anywhere else in our country. And see the order of the Supreme Court that Rudul Shah was released from jail immediately and additional compensation of 30,000 was also given to him. State of Bihar also gave some compensation, but Supreme Court says no, you pay him additional 30,000 rupees. Why? Because his personal liberty was violated for long 14 years in spite of his clear-cut acquittal from the competent court of law. So dear students, if I may conclude the concept of habeas corpus, then habeas corpus can be used to help a person who is confined or restrained by an agency of the government. It is what is called an extraordinary remedy and used to challenge the lawfulness of person's confinement or restraint. It is essentially a command from a court with proper jurisdiction to anyone who has a person under confinement or under restraint. And it applies to all confinement that is applied without lawful right or that is applied in an unapproved manner or degree. Importantly, the terms confinement and restraint are interpreted broadly when talking about habeas corpus. And this is the most impressive and most utilized writ to restore the personal liberty of the accused persons. Dear students, we are born with liberty, and if the government locks up me, detains me, takes away my liberty, then I have a right to ask the court for a writ of habeas corpus, which means the court has to tell, you will have to explain to the court why the person is locked up, and then government has to show why the person is being locked up. Thus, it gives individual liberty. It protects individual liberty against arbitrary detention. As you have seen the detention of Rudul Shah for long 14 years, even after his acquittal. So, habeas corpus came to the rescue of Rudul Shah also. And he was released from jail by the order of the Supreme Court, and at the same time, a compensation of rupees 30,000 was also awarded to Rudul Shah. This was the magic of writ of habeas corpus, my dear students. Okay.